This is Dr. David Schein, and welcome to Business Law 101. So one of the things that we talk about in criminal law is the act versus the intent. So, and it's not the same as motive. So you must show that you had the intent to commit a crime. So if you're driving down the street, you're sober, you're attentive, you have a car that's in good working condition, and a little kid darts out in front of your car and you hit that kid, it's very likely you will not be criminally prosecuted because there was no intent to do anything other than driving down the street at a normal rate of speed. Now, on the other hand, if you've had 6 drinks and the reason you ran the little kid over is because your reflexes were dulled by the alcohol, and that's why the little child was hurt, then the upper chamber may take a look at something like that and say, no, you didn't do everything you should have done. You intended to get drunk. That resulted in a horrible thing happening. Therefore, we're going to hold you responsible, even though you couldn't necessarily form the intent to run over the child. The reality is you created circumstances where you did. Now, there's also something called strict liability crime where a state of mind is not required. If it happens, you're stuck. Now, one of the terms we also want you to be familiar with is mens rea. Mens rea means that you have thought about it, that you have the required thinking in order to go over to that, in order to be responsible for a crime, that you formed the intent to commit a crime. Again, there's circumstances where intent's not required, but if it is required, then the criminal justice system must prove that you had the intent to commit a crime.